Let me tell you the chair's intent on order of bills, just so it might, just for purposes of room economy. We're going to take Senate Bill 350 by Senator Balfour first, and then Senator Grant's 366. The third bill we're going to take is H.R. 1731. I'm going to handle that for Chairman Rice. Then we're going to go ahead and I'll just tell members right now, and Senator Underman is aware of this, we're going to go ahead and take the as-passed version of Representative Shaw's bill, which is HB 872, and substitute that into 321, and we'll meet up again in conference committee, and Senator Underman is aware of that. That transaction will take about 30 seconds, I hope. And then that'll be followed finally by Senate Bill 458, bringing up the rear. So to the extent that folks want to understand that, this over here can't happen either, because you got people in back of you who are sitting down who can't see a thing. So we just have to thin it out. I'm sorry. I don't know if my skill set really, is up to that level. I just, we're all adults here, and I'm sure it'll work out fine.
I've got 4 of us with 366. We'll step outside, or you want to get rid
And Senator Grant, no. And I appreciate your patience. Do you mind if I take Senator Balfour's bill first? Thank you. Thank you. And I'll make sure he's aware of that, just for future reference. And again, we're not, and I know a lot of folks are here on Senate Bill 458. That's not going to be going out of here in 30 seconds. So no one should feel as if they're going to miss anything. They're not.
I'd be happy to move out. I'm speaking on the first bill. If somebody could just come get
Mr. Stone, I almost didn't recognize you with your beard.
It'll be coming off here.
Good. Yeah, if we could just thin it out, and again, please don't block the exit. As the meeting goes on, I'm going to have to go ahead and say something I really would hope not to. But we do have to keep that exit clear. Chancellor? All right. Senator Balfour, you want to make your way through the obstacle course? We'd appreciate it. Mr. Chairman?
Hey, Mr. Chairman.
Let me make sure that mic is on.
Believe it is.
Good. Welcome.
This bill is one that was brought to me earlier this year that clarifies the ability of the owner of a gun to get his gun back. Let's say the gun was used in a situation unbeknownst to him. Once the investigations are done, if there's a criminal investigation or there's a prosecution that they need the gun for, obviously the police can keep that, or the DA can keep that until the case is done. But once that case is done, the firearm would be returned to the rightful owner. That bill in and of itself is, I think, a pretty simple bill. Most people don't have a problem with it. There's a little amendment that I believe is going to be offered today that I don't have a problem with either, and hopefully we can pass that amendment onto the bill and pass the bill and move it along.
Thank you, Mr. Chairman. Any questions for Senator Balfour? Do you want to speak to the amendment, Mr. Chairman, or as I understand the amendment, it's a reciprocity amendment that
what I've heard about it from folks out in the halls is, if you're in South Carolina and you have a concealed weapons permit from South Carolina, that would have reciprocal agreement with the state of Georgia, so that you could bring that concealed weapon just like hopefully our people could in South Carolina. There's about 15 other states that already have this ability to have a concealed weapons license, and we have reciprocity with those states, is my understanding, Mr. Chairman.
Mr. Setzler.
Mr. Chairman, I was going to offer the amendment at the appropriate time. I don't presume we're at that posture just yet. But
okay. Let me just ask again, so we have the amendment. Any questions for the author regarding the underlying bill or the amendment? And you have it in your folder. It has SB 350 on the top. There's not an LC number on it. Let me make sure council has a copy. Okay, good. Seeing none, I've got a couple of people signed up to speak. Mr. Stone, are you still in the room?
No, he stepped out.
He did step out. We'll come back to Mr. Stone. Is Deputy Chief Sean Jones of the Atlanta Police Department here? Deputy Chief, if you'd like to come forward. Senator, thank you. We have one other witness besides Deputy Chief Jones, and then we'll go to a motion. Okay. Yeah.
All right, good evening. I'm Deputy Chief Sean Jones of Atlanta Police Department. I'm a 26-year veteran with our police department. I've had the opportunity to work in a variety of assignments, definitely a lot of field assignments. And pretty much, I really just like to thank this committee for giving me an opportunity to speak in reference to
Thank you for your service.
Thank you. As it relates to the disposition of firearms that are used in crimes, and definitely want to talk specifically about firearms that are used as it relates to violent crimes. From our police department standpoint, and I believe I speak for law enforcement throughout the state of Georgia, if not throughout the nation. Definitely when a weapon has been used in a violent crime, the police department would definitely not want to be able to put more weapons or put those weapons back into circulation, whereby they fall into the hands of individuals who would cause harm to other individuals and members of the public. So we definitely like to stay away from that. A part of what I've done, I have some photos of some weapons. In fact, we've had a number of police officers that have been shot over my 26-year career. And unfortunately, in many of the incidents, several incidents, can I pass that to you? Pass that around. In several of those incidents, we've had officers who have actually died. And from a historical standpoint, what we've done is we've destroyed those weapons. The first weapon that you would see there by Davis Arms there, that was used against officers who were investigating a burglary. Both of those officers were shot. One officer shot in the chest during that particular incident. And those weapons were destroyed, by our police department. Also, in about 2005, we had an officer who was shot as well, and he was shot and killed, fatally wounded. And that weapon was also, destroyed. I guess from a police officer standpoint, the emotional impact throughout is, putting a weapon back that has caused and taken the life of a law enforcement officer is really traumatic for just to, overstate the morale of a police agency in a sense. So definitely want to bring those points out as you begin to deliberate and make your final decision on that. So from a police department standpoint, we definitely would like to see it, those weapons not go back into the hands of the public.
Thank you. Any questions for Deputy Chief Jones? Ms. Neal.
Mine was to the alley.
Oh, okay. Ms. Abdul-Salam.
Thank you, Mr. Chairman. Deputy Turner, thank you for being here today and for the work that you do. My question is simply, in what manner does your department dispose of the weapons?
Well, currently what we do, and I'm sorry, after they've been cleared by the courts, those weapons are shredded by our agency, and they don't go back into the public.
So they're melted down?
They're shredded. We have a shredder that
Okay.
actually shreds those weapons.
Okay. And
Right.
do you know if there's a statewide protocol for that, or is it just department by department the way they handle it?
I can't speak statewide, but I know specifically from our department, I know we shred them.
Thank you so much.
I see no further questions. Thank you, Deputy Chief Jones.
All right, thank you.
No, I called Mr. Stone before. Graham, could you tell him? Thank you. Probably this way. Thank you. Could I ask the folks over here again? I know it's a small room, but that's nothing we can do. If we could just make sure that we're not standing directly behind members, I'd appreciate it. A little bit more. A little bit more. Thank you. I'm sorry to have to do that.
Mr. Chairman, with your permission, my wife is passing out an article I wrote on this bill. My name is Ed Stone. I'm here speaking not on behalf of any organization, just myself. Believe it or not, I'm not authorized to be here on behalf of GeorgiaCarry.org. However, I'm here as a very concerned citizen who has had firearms stolen from him, and I've experienced this from both sides, that is, from a department that returned the firearm to me expeditiously, and also in another instance where the firearms were kept from me for a period of more than 2 years. And I want the committee just to imagine for a moment that your car is stolen from the parking lot out here. You get a call tomorrow saying, your car's been recovered, but you can't have it back because it's needed for evidentiary purposes until the end of the trial. That trial could be 2-3 years from now. In my case, the only reason I received the guns back after 2 years was because of a plea bargain that the thief entered into. So what I would like to call the committee's attention to is line 62, which states when such firearm is no longer needed for evidentiary purposes, and have a limitation put on that, similar to the language that already exists in lines 161 through 166, so that in the case where the firearm is not needed for an evidentiary purpose, for example, ballistics testing, or to prove that the firearm's actually a firearm. I know one issue in federal court that you might need to prove is whether it was a black powder weapon or a modern smokeless powder weapon. That's not an issue in Georgia law because felons are prohibited from having both. But essentially what I'd like to see is some limiting language in the bill so that an innocent firearm owner has his firearm returned to him expeditiously. As I'm sure you understand, during these economic times, not everyone can just afford to run down to the store and buy replacements for whatever have been stolen from him. And they're being victimized twice, once by the thief and again by a prosecutor or police department that retains these firearms for a period of years. So those are my comments, and I thank you for your time.
Thank you, Mr. Stone. I see no questions. I don't know if that is the type of language that you've had the opportunity to talk with the author about or not. We don't have any language in front of us. Obviously, when we get to a motion and members can amend, generally we like to go ahead and just run it by the author just to make sure that there's to the extent that we can strike consensus on things, we do well to do so.
Mr. Chairman, I have not had that opportunity, and I apologize for that.
Okay. Well, no apology necessary. I just wanted to be open about that.
My recommendation would be to steal the language from 162 through 166, talking about photographs, videotapes, or other identification. Firearms are an item that has a serial number, and the testimony of the officer who recovered it is sufficient for a conviction.
And it's not necessarily pushback. I understand where you're going to, but I mean, at some point, depending on how long a case goes, different issues that arise in it. I mean, you know, the weapon is the thing sometimes, and I'd hate to have a situation where we're unintentionally impeaching or undermining the credibility of a prosecution because of an artificial timeline on that weapon going someplace.
I understand, Mr. Chairman, but there's never been a prosecution of a stolen vehicle lost because the vehicle wasn't there in the courtroom with the jury. They testify as to the VIN and the recovery. The same can be done for firearms. Some prosecutors like to hold on to the firearm until the end of the trial so they can parade it around in front of the jury. Not necessary for a conviction. It's not an element of the prosecution, but it makes for good theater, and that's typically the only reason it's done.
Let me ask the author if he has any I just want to make sure I touch base with the author if he has any feelings about that, about the not having seen any language. Yeah. My suggestion is, and
To a certain extent, it's been carefully drafted between police departments and sheriff's departments and so forth, but I'm just not aware of this.
okay. Thank you, Mr. Stone.
Thank you.
Did you have a question? I'm sorry, Mr. Vice Chair.
Sorry.
Actually, it's for Legislative Counsel, Ms. Travis. Regarding the point that was just raised, lines 61 to 62, is that time period that he's talking about in lines 161 through 166, is that applicable to the provisions over there in Section 2 of the bill?
The Section 5 of the bill has to do with the concept of
Personal property.
which is
but-
not exactly the same, and Section 5 is dealing with post-judgment.
With what?
Post-judgment.
Okay.
I was trying to come up with some language that would steal some of this that would make sense.
So does the Section 5, does it exclude a firearm as being personal property?
No, it does not. I think
Wh-
what I'm understanding of the witness that has testified to is this is post-judgment, and what he's talking about is pre-judgment. He's talking about in Section 2 of the bill, we're talking about in the law enforcement and/or prosecutor's hands, and it's pre-trial, and Section 5 is post.
Well, maybe we need to get that clarification because I did. Sir, is that your intent to try to set some sort of timeline pre-judgment?
That's correct. I'm sorry. I was trying to
Pre-conviction?
keep my comments brief, and I apologize if I didn't make that clear. Those two sections, one applies to appeals, which is where I was saying we should take that language and apply it to pretrial proceedings. It's the wait for the trial that causes the problem. In my case, it was more than 2 years. I had a firearm stolen from me while parked in a location where I could not carry the gun. I had to leave it in the car, and it was stolen. It was more than 2 years before the firearms were returned, and even then it was only because of a plea bargain. He still had not gone to trial. So
Okay. Well, if I may, the language, though, that you're citing to over in 161 through 166 deals with a post-judgment procedure.
that's correct.
So that really, in context of something pre-conviction, that really wouldn't apply. But, I'm not sure exactly how we would go about crafting a standard as to, cases are very different in terms of what evidence is required, and I think to just adopt a standard saying that a firearm, that the prosecutors don't need the firearm, that they only need the, just the identification number off of it and what have you, I think would probably be pushing it. But I mean, do you have any suggested procedure that you've come up with that would address that in a pre-conviction setting?
A procedure or the language? I guess I want to be clear what I'm...
Well, I mean, you had mentioned the language over in 161 through 166,
Right.
but that, as I said,
I
would
didn't
pretty
mean-
clearly not apply in a pre-conviction context.
Well, I think it does. The language about if photographs, videotapes, or other identification or analysis of the personal property will not be sufficient evidence, instead of for the appeal, it would be for the trial over in Section 2, to insert that kind of language. And then if the prosecutor needed the firearm because there's some qualitative issue, and there are types of cases for firearms where there is a qualitative issue. If the firearm was used in a crime, for instance, and they've recovered a slug, and there's ballistics evidence that needs to be done, and you need to keep that chain of custody. However, for a stolen firearm, which is what the vast majority of these issues are going to be, that is simply inapplicable, and these sorts of things, photographs, videotapes, or other identification or analysis, are sufficient to obtain the conviction, just as it is for a stolen car.
I think, Mr. Chairman, Ms. Travis indicates she's got some language that might work. Could you, Ms. Travis, you want to give us that?
It said no longer needed for evidentiary purposes, provided, however, if the prosecuting attorney agrees that photographs, video, or other identification can be utilized, such firearm shall be returned to the rightful owner.
That would make it entirely voluntary with the prosecutor. Yeah. Is that,
And
would
most-
that be acceptable with you?
It would be an improvement, I believe, but I would like to see it as just a standard, and therefore the prosecutor would have to say, no, in this case, the identification or photographs or other analysis are insufficient, and state a reason.
In the absence of the prosecutors being invested in the negotiation of this particular bill, I'm personally very wary of that, where you're entering into a realm that we're familiar with, obviously, but this comes under the category of there are things that we're not going to think of when we go ahead and put this particular amendment in, and then you've got a carefully crafted proposal right now that could be undermined with the best of intentions, but in the absence of due diligence conversation prior, not having any language in front of us, we're listening to something for the first time. The author hasn't been aware of it either, I just say that as a general. I'm not addressing this necessarily to you, Mr. Stone. I've worked with you before and respect your passion on the issue. But I think I would ask members to step carefully on this type of thing.
Sure. Thank you. I just wanted to share my personal experience, and
Understood.
hopefully it would be taken into consideration.
Thank you.
Thank you, Mr. Stone. Ms. Abdul Salam.
Thank you, Mr. Chairman. I really have a question that maybe Mr. Stone might want to give his opinion on, and then, if necessary, the author may be able to add some clarity. I'm on page 2, beginning at subsection C, line 61, and it's talking about the property of the innocent owner. And they've given the definition of an innocent owner. But if the innocent owner happens to be somebody that has a criminal background that may not be related to the case that involves the gun, would they still qualify as an innocent owner?
They would not. If you look up above, the innocent owner is defined starting on line 52 through line 60.
Yes.
So they would not qualify for return of the firearm.
And then right below, thank you, on line 63, the top of the next page, the cost of returning the firearm is to be paid by the innocent owner. Is that something that, as an owner, with wanting to get your rightful property back, would that be something that would be a hindrance to owners, you think?
No, I don't believe so. This is for shipping costs and such. The owner might not be local to where the firearm is recovered, and personally, if I had a firearm recovered a long ways away, I'd prefer to pay the shipping costs rather than have it be destroyed.
Okay. And one final, Mr. Chair, if I may, just in terms of the length of time that these guns may be needed for evidentiary purposes, in the case of a death penalty judgment, and the appeals that can go on for years and years and years with the advent of new ballistic testing and all of that, would that be a different standard for returning those weapons if it's a death penalty case?
Ms. Representative, I don't know if that question was aimed for me, but the change I was suggesting would not affect those sorts of cases, because that's a case in which the firearm would be needed for evidentiary purposes, and a photograph or other identification or analysis would be insufficient.
Right, and they could not put a real-time limit on it. That's my concern.
It really gets outside the scope of just a stolen firearm that's recovered, and the police call the owner and let him know they have it.
And, Mr. Chair, if he has the opportunity, the author may address that for me, if he doesn't mind.
Let me call another member for a question so I can make sure we take care of that. Mr. Atwood, do you have a question?
Thank you, Mr. Chairman. I think Ledge Council might be able to help me with this. Does this bill also take into consideration issues of concurrent jurisdiction, whereby the federal government could prosecute as well as the local authorities? Bank robbery is one that comes to mind to me. Two separate sovereigns, a weapon is used. One doesn't prosecute, the other one does, or chooses to. I'm trying to go through the bill again. I just thought of that, and I didn't know if maybe you could answer it without me working through the whole thing.
This only addresses something that's held by locals.
That's all I saw so far. Yeah.
It doesn't get into the issue of whether it's being held by the federal.
Because we have had cases, for example, where for some reason in a case of a bank robbery where they would have been found not guilty, and then later the feds took up the cause, or vice versa, and found them guilty and used the same evidence in both cases. So.
I would expect the authorities would need to be communicating about that.
One would hope.
Ms. Abrams. Make sure you press your button there.
Thank you. Just to follow up on Representative Atwood's question, so is there anything in this legislation that would trigger that type of communication? I mean, is it possible that under this legislation a gun could be returned, a firearm could be returned before the concurrent jurisdiction had an opportunity to request it?
In a million years, is it all possible? I think probably it's possible, but from the way that this is written, it's gone down a pretty far chain to the point where you're getting rid of it.
Okay.
I think there would be plenty of opportunity.
Thank you.
Was there, Mr. Sessler, did you have a question? All right, and then Mr. Ramsey for a motion.
This is for Mr. Stone. What's the posture if weapons are stolen? I don't know how many weapons, what the dollar value was of the weapons that were stolen from you. Is this not something that typically homeowners insurance will kick in and they'll pay for the cost of the lost merchandise? What's the posture for stolen weapons typically from an insurance perspective?
In my case, the deductible would have eaten up all or most of the value of the weapon.
Okay.
So that would have been
This may be a broader question for council or for the committee. If something is stolen and insurance pays out and it's subsequently found, I don't know who I'm addressing this to, Mr. Chairman. What's the posture from an insurance perspective if I've gotten say $2,500 in firearms are stolen from someone's home, insurance pays $500 deductible, insurance pays $2,000, they're subsequently recovered. How does that, I guess, as counsel for an insurance company, how does that?
I've just dealt with it with cars. I never, I mean, I guess at that point, I think a lot of that's going to be dictated by the terms of the actual policy itself. And I would be hesitant to go ahead and say exactly what's going to happen. You got standard practice, in auto and property, but in terms of an item like that, I think you'd want to, if it were me, I'd consult the terms of the policy just to make sure. So I don't want to lead you down a path that just may be wrong.
Okay. I just want to make sure there was some remedy, typically that firearms in a home are covered under some insurance arrangement. So if it weren't a collector's item, it weren't a family heirloom firearm, at least there's some. If we were leaving people exposed without any access to insurance, their gun rack is cleaned out. They have no means of self-defense, and I'm trying to understand this in context. That's all.
Yeah, obviously it would be under a greater homeowner policy, and probably under a particular rider, for that policy, given the value that we're talking about. But again, I'd want to take a look at the, depending on the value of the items, different companies are going to have different approaches on that, probably. Yep. Mr. Ramsey.
Mr. Chairman, I have a motion, and also just a quick comment. I'm very sensitive to Mr. Stone's concerns, like you. I think it's trying to do something on the fly here is probably not a great idea. But I think we're going to amend the bill, so there may be other opportunities along the way for the author and members to keep looking at it. So I think it's in our best interest to get property back in people's hands as quickly as possible, and to the extent that there's no longer a law enforcement need to have it, I think we should get it back in their hands.
The gentleman's point's well taken. I mean, as a practical matter, this is going to go back to the Senate for an agree. I would ask anyone who may have an issue, including Mr. Stone or whoever, to go ahead and get with the author sooner rather than later. There's nothing precluding an amendment when it comes back on the agree and send it back. I think I, like anyone else, would defer to the author on that.
And in that regard, Mr. Chairman, I move do pass SB 350, which is LC 215125S.
Mr. Ramsey moves due pass of SB 350, LC 295125S, second by the Vice Chair. Are there any amendments? Mr. Setzler.
Mr. Chairman, there's an amendment that's it's crafted on a photocopy piece of paper. It says SB 350 across the top. Again, this amendment simply provides for the reciprocity issue that the author referenced in his initial presentation, and I'd like to offer this before the committee as a formal amendment.
Let me ask counsel if she's clear on placement, structure, and all that.
The only leeway that I guess I would ask the committee is that for some reason in my head I have it that maybe these words are used somewhere else in the same code section where it says whose laws recognize and give effect to the license, or something else. There's something else within 1611 126 that deals with the same issue. I might be wrong, but if the effect of the committee will is that we don't care if another state has this recognition, it's just as long as they're licensed by another state, if I can make that correction if it's necessary within that code section.
Out of due diligence to the author, we are talking about simply if that ability is held in another state, period, with no other qualifier, right? Yeah, that's the understanding. So I mean, and I'm not trying to modify the gentleman's amendment, but it would be with that understanding. And I think there'd be an instruction to go ahead and draft accordingly, unless there's objection from a member of the committee. I think it'd have to be a separate section of the bill, wouldn't it, Ms. Travis? Okay. Mr. Ramsey, is that acceptable?
I think it was his motion.
Oh, I'm sorry, Mr. Setzler. I thought it was.
Yes, sir, Mr. Chairman. It
Okay.
is.
Any further discussion on the amendment? Ms. Neal, did you have discussion on the amendment? No? Okay. All in favor of the gentleman's amendment signify by saying aye.
Aye.
Opposed? The ayes have it. Are there any further amendments? Seeing none, we have a move. We'll go ahead and move do pass by substitute on LC 295125S. We have a motion and a second. We have an amendment that's been adopted. We have we'll go ahead and make the motion by substitute. Any further discussion? Seeing none, all in favor of the gentleman's motion signify by saying aye. Aye. Opposed? The ayes have it. The motion is adopted. Thank you, Mr. Chairman. Let me call. Is Senator Grant in the holding room? There he is. I said is Senator Grant in the holding room like it's some sort of custodial facility.
Well,
in the waiting room, I should have said, or in the green room, maybe.
well, you actually have a very comfortable office in there. Yes.
It's
Thank you, Mr. Chairman. I think we have some other folks with DJJ here that if you would like to ask any questions, but unless you have some other reason to go through Senate Bill 366 in its entirety again, I will just go over the substitute and the three changes that were made. We're operating off of LC 295263S.
LC 295263S, and that should be in the folder. If any member does not have that, if you could let us know.
And I want to thank Legislative Counsel. Ms. Travis was very helpful in trying to help perfect this language. The first change that you'll see is on page 2, lines 58 and 59. We did have the conversation about the guard lines. In Title 42, the guard lines as defined in 50 through 56 is identical, but we felt like with Legislative Counsel's suggestion that we should put lines 58 and 59 in place in this other section so it refers back to that more definitive reference. On page 3, in the area of lines 76 through 79, we restated the language, or Legislative Counsel restated the language to make sure that this is a three different ways that someone can be directed not to take items into the center. Verbally by a staff member, in writing by a staff member, and as directed by rules, regulations, and policies of such center. So I think this gets to Representative, or restates what had previously been there and gets to Representative Coomer's concern about a staff member being able to unilaterally allow something that would otherwise be restricted. I think that staff member could unilaterally make it more restrictive, but if it's restricted through policy, he's not able to, he or she would not be able to allow that introduction of that contraband. And then finally, on page 4, line 100, this gets to Representative Pack's suggestion that we make sure that we are not limiting ourselves in future technological advancements by including the words including but not limited to when we describe telecommunication devices. I'll be happy to answer any other questions, but I think this does meet the needs of the department, and I hope the committee will see favorable to report this out.
Counsel, in your opinion, we've addressed the structural issues that we talked about in the last meeting. Thank you. Questions for the author? Seeing none, I'm doing a quick scan of the Make sure I haven't missed anybody. I haven't. What's the pleasure of the committee?
Move to pass.
Vice Chair moves due pass of LC 360, SB 366 by substitute LC 295263S. Is there a second?
Second.
Second by Ms. Byrd. Are there any amendments? Seeing none, any further discussion? Seeing none, all in favor of the gentleman's motion signify by saying aye. Opposed? The ayes have it. The motion is adopted. Thank you, Senator, for your patience.
Thank you, Mr. Chairman and members of the committee.
Senator Grant's going to go ahead. There's a form that needs to be filled out at Rules, and as soon as that goes on, as soon as that gets turned in, which I'd suggest doing right now, it'll be on the consideration calendar. So you just ask for it one time.
Thank you all for your help.
Okay.
We appreciate
Thank
it
you.
very much. Thank you.
I made reference earlier to SB 321. That's the metal theft bill that's come over from the Senate and Senator Unterman. What you'll see in your folder I think what you'll see in your folder is a substitute. I missed it. It's substitute for SB 321. It's LC 295267S. As per my reference earlier, what we have done, and Senator Unterman is aware of this, we have taken Representative Shaw's HB 872, the House version of our initiative on metal theft, as it passed the House, and substitute that in for SB 321, and then with the understanding with Senator Unterman that we're certainly going to continue the conversation ultimately in conference. Mr. Ramsey.
I have a motion, Mr. Chairman. I move due pass the committee substitute to SB 321, which is LC 295267S.
Mr. Ramsey moves due pass of SB 321 by substitute LC 295267S. An important second by the Vice Chair. Are there any amendments? Seeing none, any further discussion? Seeing none, all in favor of the gentleman's motion signify by saying aye.
Aye.
Opposed? The ayes have it, and the motion is adopted. H.R. 1731, I'm going to go ahead and handle for Chairman Rice. This is simply a study committee resolution for the study of Title 40, our Comprehensive Motor Vehicle and Traffic Reform Study Committee. Recall that the Criminal Justice Reform Council, let me get a little bit of order, and maybe a closed door would help too. Okay, thank you. Recall the Criminal Justice Reform Council last year, pursuant to HB 265 by Chairman Neal, undertook a really Herculean effort in taking a look at criminal justice reform in this state. One of their recommendations had been to make certain changes to our traffic laws. Those changes are very large in nature, and from a systemic standpoint to our court system, have very far-reaching effects. My understanding, and I thought I saw Mr. Casaro with the AOC. My understanding is that the AOC is on its own, and in conjunction with the agreement of the Chief Justice of the Supreme Court, undertaking its own study in the off-season on the effect of the potential of moving traffic law from criminal to civil, amongst other considerations that go along with traffic law in general, including jail effect, county revenues, etc. All the different moving parts, effects, and results, intended and unintended, of having some sort of shift on traffic law from criminal to civil. This study committee will go ahead and take a look at not just that aspect that came out of the Criminal Justice Reform Council, but also any other reform that needs to be done in Title 40. And the judges that I speak with, they describe Title 40 in different ways, to say that it can be cleaned up and made more efficient in terms of its practical applicability would probably be the understatement of the year if you talk to some state court judges. So I think this particular study committee, in conjunction with the AOC's study on traffic courts in general will be a good combination and will probably almost certainly form part of the basis of Chapter 2 of criminal justice reform coming up in January 13. And that's just the backstory on this particular resolution. I'll answer any questions if there are any. If not, I'll go ahead and take a motion if I can get one. Vice Chair moves do pass. Second by Mrs. Cooper. Any amendments? Any discussion? Seeing none, all in favor of the gentleman's motion signify by saying aye. Aye. Opposed? The ayes have it, the motion's adopted. Okay. Let's take 5 minutes. I understand Senator Loudermilk is on his way. Let's take 5 minutes, and then we'll begin consideration of SB 458. It'll be a real 5 minutes too. Let's call Senate Bill 458. I appreciate everyone being respectful of people's boundaries here along the wall and so forth. So thank you for that, past, present, and over the next hour or so. All right, let's have the committee come to order. Again, let's please try to keep the exit clear. Senator Loudon, let me ask you to go ahead and make sure you're talking to the mic and position that however you need to.
Sounds like it's working.
Okay. And welcome.
All right. Thank you, Mr. Chairman, and I appreciate the time. And as you know, we're doing business up on the Senate floor, so I'll make my my comments brief because I may have to run out to make a vote or two here in a few minutes. A couple of real key legislative issues coming up here. But I also have with me an expert witness who's very knowledgeable about this subject matter, Mr. D.A. King, and he may be able to answer some of the questions that I may not be able to if I have to run out. So I appreciate your indulgence. Senate Bill 458 really does three things. I know there's been a lot of focus on one portion of this, but let me start off with the other two parts of the bill that I think gets broad support. You know, we occasionally have unintended consequences with legislation that we pass. Just the work that we do, it's hard to see every angle of the effect it may have. And one of the things that we did, which was a good thing, is require that proof of citizenship or the legal status of being in this nation, in this state, be provided whenever you receive any public benefit. And according to federal law, as well as our own state law, public benefit not only includes those social programs you typically think of, the food stamps and public housing, et cetera, but it also includes professional licensing. So let's take, for instance, a nurse's license. To get a nurse's license, you have to, as well as all the other requirements, show proof of citizenship. Well, the way the law reads now, when you renew that license in 2 years, you have to show your proof of citizenship again. Well, citizenship doesn't change. So part of this bill simply streamlines that process and makes it to where once you've proven your citizenship to any agency, you never have to show that to that agency again. You never have to go through the verification process. So if you do it to one agency, you never have to do it again. But let's say you've done it for the nurse's license with the Secretary of State's office, but you also are applying for public housing assistance. You would have to do the verification with public housing once, but you wouldn't have to renew that and keep doing that over and over again. Other portion of the bill deals with security of documents that we accept, basically foreign passports. Right now, we do know that there are occasions to where someone who is already physically in the country can go to certain consulates and receive a foreign passport after they're already here. What this section does is simply say that if you are using a foreign passport to apply for any public benefit, you also have to have, I believe it's a I-94A or an I-94, which, and this is, we're looking at lines 199 through the end of the bill there. These are documents that are provided by ICE at the border. When you enter into the country and you show your foreign passport, ICE gives you this form. So this will show the state, local governments, county governments, that that passport was in your possession when you physically entered into the country. The other portion of the bill, which is probably why you have such a crowded room here today, deals with really all we're doing is clarifying legislative intent that goes all the way back to 2006. You may remember Senate Bill 529 that we dealt with when I was still in the House at that time, Senator Rogers' bill. And what we did in that bill was we looked at federal laws, what was considered a public benefit. Post-secondary education, when I say post-secondary education, I mean public post-secondary education, meaning our university systems and our technical colleges, by federal law are considered a public benefit. And in the legislation, we reference that federal law. Somewhere over time, the university systems, technical colleges have reinterpreted that to mean it's only a public benefit if they receive in-state tuition. So all we're doing in this bill is just clarifying what our legislative intent was in 2006, is that post-secondary education is a public benefit regardless of whether it's directly subsidized or not, because it's in my belief that even if a student who is here illegally is attending one of our state colleges, universities, they are receiving a public benefit because, as you know, we go through the budget process, we budget a lot of money, the university systems, and not all that goes to tuition. Some of that goes to capital projects, it goes to the buildings, it goes to the housing, it goes toward the computer systems that go into the public universities. So all we're doing is clarifying that portion of our legislative intent. This does not apply to private schools, private universities, those who are here illegally and want to attend one of the private colleges. That's up to the local university, the local college, of whether they accept them or not. One of the arguments you may hear today is what is wrong about allowing someone who may be here illegally to take one of the seats in one of our colleges, universities, if they just want to better themselves and they want to become a productive member of our society. Well, that's a good argument to make. However, it is a federal crime to hire someone who is illegally in this country. So even though they may complete with a bachelor's degree, a master's degree, or a doctorate degree, they cannot legally gain employment in this country. Thus, they would have to leave the country. We also have had testimony from even some in our own body of the legislature in support of this legislation, to where their member of their family was not able to get into a college because the classes were filled. They were a member of the armed forces, and because of different circumstances, they tried to get into a particular college, was not able to get in. So we know that our colleges are filling up. Currently, the university system does not allow illegals to attend for the colleges. So they've said because they're competitive and we're already have stipulations on those that can get in, we're banning them from those 4 colleges. So simply this would just take what the policy is of the university system already that they're doing with those 4 universities and apply it to all technical colleges and schools in the university system. And again, all we're doing is clarifying what was our legislative intent in 2006.
Thank you, Senator. I know Mr. O'Sullivan with the Secretary of State's office, we had chatted earlier, and I know that their concern was on the licensing piece, and that's a portion of the bill that the author has worked with the Secretary of State's office, and that and so that office will say amen, correct? Absolutely. Okay. And so I wanted to make sure we covered that from the Secretary Kemp's perspective. Questions for the author, Ms. Abrams.
Thank you, Mr. Chairman. Senator Loudermilk, I have a few questions. To begin with, do you believe that students who take online courses are receiving a public benefit?
Well, it's hard for me to answer that because I don't know exactly how those courses are funded, because it's really going to be hard for me to answer that question without more knowledge of how the online courses are set up, how they're funded. Is it taxpayer dollars through the local taxpayer dollars?
Well, if it's an online course offered by the University System of Georgia, would you consider online courses to be a public benefit?
Yes, I would.
Would you then say that this bill should prohibit the taking of online courses as well?
I guess if they're enrolled in the college.
But let's say they're not enrolled. If they're simply taking an online course, would you say that there is a nexus for an online benefit, for a public benefit at that moment?
without being with the esteemed legal mind that you have, and there's a lot of other information to consider, I kind of have a hard time answering that, but I would initially assume so.
Okay. And did you provide a fiscal note with this legislation? And the reason I ask is that although there was not one provided with HB 87, analysis done by the Secretary or by the Commissioner of Agriculture found a minimum of a $75 million impact to the state. Is there a fiscal note attached to this legislation?
There's not. I don't see how a fiscal note would be needed because basically we're just talking about not admitting students or people who have entered this country illegally. So I don't know how that would be a financial impact on the state. So there is no fiscal note associated with it.
So if there is current revenue that is generated by the attendance of undocumented students in our public colleges and universities, and those revenues cease to be available to the state because we deny them access to those colleges and universities, do you believe that is a fiscal impact?
No, I do not, because as we've already seen with 4 of the universities, because they're already at capacity, there's, we're not allowing them into those schools. So I don't see how you correlate that because one particular type of student is not getting a seat, that seat's more than likely going to be filled by someone else.
However, would you, just to posit this out, given that you raised the question, if student A pays $5,000 for a seat and student B pays $20,000 for the same seat, and we remove the ability of student B to pay the $20,000, and we replace them with student C who only pays the $5,000, given that there's a $15,000 loss, would you not consider that a fiscal impact to the university system of Georgia?
No, because I think what you're getting at is then the university system may be put in a position of choosing, which is one of the concerns we have with this, because you're kind of getting to the root of part of the problem. University system is using the federal databases to determine the eligibility or the legal status of someone in the state, like we've dictated should happen. But instead of choosing whether or not to allow that student to attend, if let's say the applicant turns out to be an illegal, what they're doing is just charging them out of state tuition instead of giving that seat to a legal citizen. So what you're doing is the university system is now in a position of, if I got one seat, let's say I'm a business. If I'm a restaurant, I only have one table left. A family comes in, wants to take that table, but another family comes in and says, tell you what, I want to get a seat, but I'm going to pay 3 times whatever your menu price is. I'm likely going to give the seat to the person who's paying 3 times the amount. So your analogy is getting to a point of basically saying, if we pass this, no longer are we going to be able to go after those who are going to pay 3 times the amount to get in, regardless of their legal status. Also, the situation, it is a federal crime, from my understanding, to encourage someone who is illegally in this nation to remain here, which this policy does.
Do you, my final question, Mr. Chairman, and just to clarify, I didn't draw any inferences. I was simply asking information, and I was asking if you believe there to be a fiscal benefit or fiscal harm. I appreciate your extension of that question, but that wasn't my question. My final question, however, goes to the question: do you believe that it is possible to be lawfully in this nation, to be undocumented because the documents have not been processed due to bureaucratic confusion and bureaucratic delay? And if so, do you believe that those persons who have abided by our law should be denied access to education if they've complied with all of the laws and all the regulations, but through no fault of their own, they do not currently have documented status? And the corollary to that is that there is certainly, do you acknowledge that there's a difference between someone who is here unlawfully and someone here who's undocumented, not because of their fault, but because of some bureaucratic distinction or bureaucratic snafu?
I don't totally agree with your statement, because if someone is here, as the word that you used, undocumented, they're going to, but they're caught up in some type of legal snafu, or by the inefficiency of the federal government, they haven't received their permanent resident status, they will have some type of documentation that they physically entered this country illegally. And I've actually been in discussion with some that are in that situation. But they have, and usually what a situation like that is someone who came here legally and they have a visa to be in this country, and while they were here they applied for permanent status, and they're waiting on the final approval. They do have documentation from ICE or immigration stating that they are in process and that their process is pending, is tentatively approved, something like that, there is documentation existing for the type of person that you're talking about. So I don't believe that it is a common case that you can legally be here in this country but not have some type of documentation stating that you have entered this country legally.
Let's say, for the sake of argument, that it does happen, that there are indeed entire rafts of immigration lawyers who exist solely for the purpose of that gap between having documentation and not having documentation. Do you believe that a person who was allowed to enter lawfully but who currently does not have the documentation required under this bill, that should that person be denied access to public education during the time that it takes for a bureaucracy to successfully process those documents?
Well, it's hard for me to answer that because we're really dealing with a totally hypothetical situation in which we don't have any evidence of whether that actually exists or not. I don't have any knowledge of a situation like that existing, so I can't.
Could you posit if that is true? Let's assume that this is true for the sake of argument. I'm just trying to determine sort of the lengths of and the extent of this bill and sort of your intent. Would you find it permissible for an undocumented student to attend a college if their lack of documented status is purely bureaucratic and not through any fault of their own?
Well, again, it's hard to answer a question that's purely hypothetical because I can make a hypothetical situation about any bill that we pass here.
Thank you.
Coming around, Ms. Neal.
Thank you, sir. Actually, the leader took some of mine. I have to go down my list now. One of the questions what do you consider to be, okay, let me give you an example, hypothetical, if you will. Okay, if a person can't get into a college, what data do we have that demonstrates that the student, like for instance, say a student has a student visa, say they outperform the U.S. citizen who was trying to get to the same school, how does this bill address the difference between a kid getting a spot who was just simply outperformed by a student that's here on a student visa, but they're technically an undocumented person? Does this bill affect the student that has a student visa outperform the regular citizen? Will they still be denied under this bill?
Well, I may defer some of this to Mr. King, but if they're here under a student visa, they're documented, so it wouldn't affect them, in my opinion.
Well, I'm not quite clear because I'm trying to reference the way how you address it to Ms. Abrams. I'm trying to get clarification because it didn't sound as though that's what you meant, but I guess my concern is sometimes we assume that positions in colleges are being taken up by just simply illegal immigrants who have nothing at all, but there are also times when the positions are taken by people that have student visas that are here.
Well, they're legally here, and this doesn't affect any foreign students that come here legally and they have a visa to come in the country. This is just simply those who have illegally entered the country.
Is there something, can you direct me to a portion of the bill that makes it where those students that do have the visas are exempted under this?
Well, there's no exemption because they're legally if they have a student visa, they're legally in the country. They have legally entered the United States and they're here under a legal visa, so there's really no exemption needed in the code for them.
Okay. Did you have something?
Well, yes, ma'am. Thank you. Part of the confusion here is coming from the constant mix in use of terms between undocumented and illegal. People who come to the United States lawfully are not affected, or who are present in the United States lawfully are not affected by this bill even a little bit, regardless of what word we use to describe the people who are not here in accordance with our laws.
Okay. Okay.
Mr. Chairman, if I may be excused, I just got notified we have a major piece of legislation on the floor up for a vote, so I need to go back up there. I'll be glad to come back down if I need to.
If you can.
Okay.
I mean, I understand that that's a fluid situation at best.
As soon as I vote, I'll come back down.
Thank you. Ms. Abdul Salam.
Thank you, Mr. Chairman. My question, which I was hoping that Senator Loudermilk could address, if you have students, well, since we do have students in our public schools now attending every day, and we are receiving funds based on their attendance in these public schools, then this legislation, at the time that they become college age, actually stunts them and cuts them off from what we've been providing funds for from grades K through 12. And if that is the case, is this going to have an effect on the public school students now? Will students be, I guess, encouraged to just not go? Will the state of Georgia give up the funding that they're receiving for these students currently if there's no hope for them going on to college?
Mr. King, you want to take a crack at that?
I will, Mr. Chairman. Thank you. Currently, because of a Supreme Court decision in 1982, we as a nation are required to provide K through 12 education to anyone regardless of their immigration status. So, by the same token, the way most people read federal law is that there are many public benefits for which people in the country illegally are excluded. Post-secondary education is one of them. Whether or not someone will continue their K through 12 education in Georgia knowing that they will have a difficult time going to a public college is an unknown. They can still go to a private college.
I guess my question speaks more to the public benefit that we're experiencing. You know, there is a public benefit to them attending the public schools.
Well, yes, ma'am, but by the term public benefit is involved in this legislation and in current Georgia law describes benefits administered by the state of Georgia, like welfare, retirement, housing assistance, post-secondary education, commercial and professional licenses. So I honestly don't know how to answer your question, because I don't know that somebody who is informed of the fact that they cannot go to a publicly funded university if they're here illegally is going to make any decision. I can tell you that the purpose and the ambition of every state illegal immigration enforcement bill is to serve as a deterrent to people who are considering what state to go when they cross our borders illegally. It is the hope of most people involved in this that this will further the inhospitality of Georgia to people who are here legally, and by the same token, and I think this is very important, make it clear to the people who do obey our immigration laws, the real legal immigrants, that they are not just welcome, but we're looking out for them, and we're not going to take any chance on letting a college seat that's publicly funded go to somebody who's not even eligible to work upon graduation. We're trying to make sure that U.S. citizens and real legal immigrants are able to get a clear shot at this particular public benefit.
I just would ask that when we're talking about this, and even though we're talking about post-secondary education, the message is still going to those younger students right now, and we are, I don't know whether you call it a public benefit or not, but we do accept funds for them every day.
Yes, ma'am.
And we encourage them to attend. There's a law that they must attend. So, I mean, what are we really saying, and what are we really doing, and why are we doing it?
Well, I hope that everybody that's involved in the legislature is, what they're saying is that Georgia is very, very accommodating to real legal immigrants and not so much to people who don't obey our immigration laws.
But a child can't make that, I mean, they can't make that happen.
And I fully agree. It is a sad fact of our life that there are parents who bring their children into our country illegally or bring them legally and overstay their visa on the hope that sooner or later, because they have children in this state, that they can adjust that legal status or illegal status. That, in my book, was not part of your question, but I believe that to be child abuse on the part of the parent.
So we're not going to anytime soon say we're no longer accepting the federal dollars for the education of the children because we just don't believe that they ought to be benefiting from it. We're not going to turn that money down.
I wouldn't think so, no.
Okay. Thank you.
Vice Chairman.
Mr. King, following up on a question that was asked to Senator Loudermilk a moment ago about a fiscal note, would I be correct in saying that the provisions of this bill would have no direct fiscal impact on the state government. Is that correct?
That would be my opinion. As far as a fiscal note, there was conversation earlier that it needs to be cleared up. In addition to it being a federal offense to encourage an illegal alien to remain in these United States, it's also a federal offense to make a commercial profit from employment or other actions. So I'm not clear on why there would be a fiscal note on a bill that is simply saying that this is legislation saying that we should obey the intent of a law we passed right here in this room 6 years ago that is aimed at protecting public benefits for people who are eligible. And I've been saying that for a long time. I can't think of a different way to say it.
Right. Thank you. One other thing I wanted to ask you, I want to give you a scenario. Suppose an individual who is unlicensed to drive goes to the Department of Driver Services office in his or her town and goes to apply for a driver's license, takes the driver's license test, goes through the eye exam, whatever all they do there, and they go through all the steps to get the driver's license. They pass the test, and then the driver's license office says, something's wrong with our machine that generates the license, that prints it out, and so we can't issue you a license today. Is that person, based on your understanding of the law, is that person legal to go out on the roadways of Georgia and drive?
Not having been issued a driver's license, I would have to say no.
So that might be similarly labeled a bureaucratic snafu that might result in a person not being able to exercise some legal privilege.
It would, yes, sir.
Okay. That's all.
Mr. Coomer.
Thank you, Mr. Chairman. I had hoped to be able to ask the author a couple of questions, mainly about the intent. I think, though, he probably answered these questions when he was here, but I would like to make the comment for the members, specifically with regard to lines 23 through 51. I believe the testimony was pretty clear that it's really the intent of this bill, and that language in particular, to define exactly what public benefits are, and to give a more definite and clear understanding of what a public benefit is. And I have some. I'm going to offer an amendment at the appropriate time to clarify some of that language, specifically to clarify that it's not the role of the Attorney General to be setting what public benefits are, but it's instead a role of this body, and so I have language to that effect, and also to clarify that in the list of those public benefits that we would include public post-secondary education as one of those public benefits, so as to clarify the meaning and the intent of the author.
Ms. Abrams. Okay. I see no further question, Mr. King. Thank you for being in.
Thank you very
Mr.
much,
Pack,
Mr. Chairman.
hold on. Mr. Pack has got a question.
Quick question. I think the testimony was that this bill is not trying to tell private colleges what to do, but by incorporating 8 U.S.C. Section 1621, which only says post-secondary education, does that leave open the room that we're indirectly maybe telling private colleges that they can't do this either?
I don't believe so, no, State Representative. The reference to 1621 was set forth in the 2006 law, the Georgia Security and Immigration Compliance Act. And those of us who worked on that bill thought that by using a reference to federal law describing public benefits, we had our definitions down without any possibility of them being misunderstood or redefined. 1621 simply defines, as you know, state and local public benefits. A public college would be a public benefit, but someone paying tuition to go to a private university would not in any way be affected by that code section.
Oh, you're waiting for me? I'm sorry. I guess Representative Coomer's amendment, if it's adopted, would specify that. But I'm looking at state and local benefit defined, which is incorporated into the bill. It says it doesn't have the word public post-secondary education in there. It just says post-secondary education.
Yes,
and
sir.
that's why I brought that up.
And I'm pretty sure very soon in this meeting that will be taken care of.
Thank you, Mr. King.
Thank you, Mr.
Let me ask Chancellor Huckabee to come forward. Chancellor, welcome.
Thank you. Appreciate the invitation.
For those who don't know, Chancellor Huckabee, far more importantly, is a former member of the State House of Representatives. Had a long, illustrious career in the State House.
It was short but very brilliant. He was my seatmate.
That's our story, and we're sticking to it.
That's right.
Welcome,
Good afternoon,
Chancellor.
ladies and gentlemen.
Let us know who you have with us.
I have with me
Chancellor.
one of our legal counsel in Board of Regents, Darrell Goodwall.
Thank you for being here.
And if we get into the legal weeds too deep, I'll rely on him.
Thank you. I rely on Ms. Travis for exactly those situations.
Well, thank you for the opportunity to come before you to discuss Senate Bill 548. The issue before us is a complex one with strong feelings on all sides. But what is great about our country, whether you're in it legally or not, is that we like to have a forum to express our opinions about public policy. We all know of the vigorous debate about undocumented immigrants receiving public benefits. In the university system, the debate centers on whether undocumented students should be admitted, and if so, how much should they pay? Today, I'm here to make the same request of you that I made before the House Higher Education Committee regarding House Bill 59 and the Senate Judiciary Committee regarding this bill. And that request is to allow the university system to continue to implement its current policy. The Regents policy was approved in October 2010, and its 4 points went into force last semester, and they are: 1, the addition of language on all applications for admissions that outlines the legal penalties for false swearing or knowingly providing incorrect information on the forms. 2, the addition of language on all applications that, for the first time, requires applicants to state whether they are seeking in-state tuition. This helps institutions make a decision on whether or not additional residency verification is necessary. 3, a requirement that USG institutions verify the lawful presence in the United States of any applicant seeking in-state tuition and not applying for federal financial aid, which has its own very strict verification processes. And approximately 60% of our students do apply for federal aid. So if verification cannot be made at this point, these students are charged out-of-state tuition. 4th, a policy that any person not lawfully present in the United States shall not be eligible for admission to any USG institution which, for the 2 most recent academic years, did not admit all academically qualified applicants. And there are 5 in our system rather than 4 who do not, under any circumstances, accept any undocumented applicants. In short, we believe this policy assures undocumented students do not receive a public benefit since they must pay out-of-state tuition, and that no undocumented student will be taking a seat in a class away from a Georgia student, since our selective institutions are not allowed to admit undocumented students. Let me just state parenthetically, it was stated earlier, if a student applies to one of the other 30 institutions in our system and meets the academic requirements, they are admitted. There's no enrollment cap on those students. So under this policy, an undocumented student who is required to pay out of tuition will not take the place of a otherwise Georgia citizen who meets the same academic requirements. I believe our current policy addresses the concern some of you have that the system should ensure that all undocumented students pay out-of-state tuition.
that no Georgians should be denied a seat in the college if they were academically qualified because of an undocumented student, and that educating undocumented students would not cost Georgia taxpayers. I respectfully ask you to allow our policy to work and to determine if it addresses your concerns. We will monitor it closely through both auditing and staff reviews, and will be happy to report to you on the results of that audit. I can assure you that we will respond quickly and decisively to correct any exceptions should we identify non-academic compliance by any university system institution. Of the 318,000 students enrolled in the system last fall, less than 0.1% are undocumented. All pay the out-of-state tuition rate, which at slightly more than 3 times the in-state rate more than covers the cost of education. No one gets a free benefit. The 5 institutions under the admission ban, as I said earlier, admitted no undocumented students. I would like to raise a related issue, and I do so with the utmost respect of this committee. Graduating more students is a key goal of the system as we work to help Georgia prosper. Even those who are here through no fault of their own, it makes sense to me that we should educate them to the highest level possible. It helps our state economy, both culturally and educationally as well. Georgia is in the mainstream with its current policy. Only 2 states, Alabama and South Carolina, ban undocumented students from attending any public college or university. Texas is actually more liberal than Georgia, and so is Arizona, as it allows undocumented students to attend, and particularly in Texas, allows them to pay in-state tuition. Like most states, Georgia allows college attendance for undocumented students at the out-of-state rate, and like most states, Georgia's current policy is a common-sense approach to a very complex issue. Long term, we want to protect Georgians, promote the state as a place to do business, and encourage all individuals to pursue education. But we do not wish to offer anyone an undue benefit. I believe that the current policy of the board achieves all of those goals, and would ask you to consider giving us the opportunity to continue to address this through board policy. We will continue to work closely with you to make sure that our policy achieves our common aims. Ladies and gentlemen, I appreciate your attention, appreciate the service that you provide to the state of Georgia, and would be happy to answer any questions.
Vice Chair. Thank you. Chancellor,
yes, sir.
I wanted to clarify which schools are the ones that you do not allow any illegal aliens to attend whatsoever.
Our 4 research universities, that's Georgia Tech, University of Georgia, the Georgia Health Sciences University, and Georgia State University. The 5th one is our targeted liberal arts college, which is Georgia College and State University. They have higher admissions requirements.
Okay. Why would you have a different policy for them than for all the 30-something other institutions in the system?
Because they do have selective admissions, and there would be instances where otherwise qualified students would not be admitted, and those students would be eligible to attend almost any other institution in our system. So that's why we differentiate between those 5 schools and the remaining 30.
Okay. Now, do you believe that by providing a public education to undocumented immigrants or illegal aliens, as it were, that is providing encouragement to people who are illegal to come into our country illegally and to try to obtain benefits like this?
I would hope not. I think particularly the universal students we're dealing with here are those who have graduated from our public high schools. From what I know, they all came here as small children at a time when they made no decision in that process. So I think to prevent them having any access to public higher education is somewhat punitive.
Even though you may, as you say, require them to pay out-of-state tuition, and that they may in fact be paying the cost of affording that education. Don't you know that there are other benefits out there that these undocumented students ultimately may drain from public coffers, specifically look at health care costs that are spiraling out of control?
You may be correct. I'm not confident to comment on that. I don't dispute you one way or the other.
Okay. Well, I'm just curious. Are you speaking on behalf of the Board of Regents here, or are you speaking on behalf of your own opinion?
I'm speaking on behalf of the Board of Regents, and I concur with the Board of Regents policy that they adopted in October 2010.
Okay. So the Board of Regents feels that it would be best that we not pass any legislation, but let you guys handle it in the manner that you have outlined.
Yes, sir. We feel that the policy that's in place now is working, just given the low number of students who are coming into our system. And we would be the first, if we find out that it's not working, we will report that. And we will do audits every year on this very important issue.
Okay. And just to clarify again, so the policy of you and the Board of Regents would be that illegal immigrants, illegal aliens, should be allowed to attend Georgia institutions of higher education as out-of-state tuition-paying students.
That's correct.
Okay. Are you aware that that opinion would not be in keeping with many of those here in the legislature and across the state that feel very strongly about immigration enforcement?
Oh, I'm very much aware that this is a controversial issue. It's a sensitive issue, and I respect the opinions of those who disagree with us. But I'd also say that we're right in the mainstream of about 45 other states who essentially have assumed the same posture that we have. And I mean no disrespect to those who have a contrary opinion.
All right. One other thing I wanted to ask. You're aware of the legislation that was passed recently, which Representative Ramsey was a lead sponsor on, that dealt with tightening enforcement on illegal immigration here in Georgia.
Yes, I am.
Don't you think that the policy that you're advocating for, that the Board of Regents is advocating for, and seeking to avoid any legislation on this topic, is actually not consistent with the approach that we've taken through the legislation that this body passed?
No, I don't. I think we're making a good faith effort to make this as public policy responsive and responsible as we can. And we would ask, just as we are asking in the law we passed last year, to give it some time to work, and we're asking for the same opportunity here in terms of the Regents' policy.
Okay, but again, and this is my final question, your suggestions and your policy and the Board of Regents' policy has no sort of solution to offer in terms of the skyrocketing costs of health care that's associated with illegal immigration in this state?
No, sir. I wish you did have a solution, but I don't.
Thank you.
Mr. Ramsey.
Really kind of a technical question. You cited the number of students that are, I think you said, entering our system this year that are illegal. What's that number?
308, 1/10 of 1% of 318,000.
Okay. So
it's about 318 or 350 students.
Okay, and that's how many are entering?
That's how many were admitted this last fall.
Okay, so that doesn't, you haven't counted all that are already in the system, correct?
I'm not confident we have.
Okay, so there's no telling.
We're in the process of going back and verifying all that.
Okay, so there's really no way to know how many are actually in the system. I guess there's a
way.
way.
There is a way.
We haven't. We just haven't determined it yet.
That's right.
Okay, thank you.
Ms. Abrams.
Thank you, Mr. Chairman. Chancellor Huckabee, I have a few questions. One, to respond to an earlier comment made, I think in direct response to a question I raised. Is it not true that the University System of Georgia is a nonprofit entity that is not allowed to generate commercial profit?
That's correct. We have to file tax forms every year to be sure we're not breaking the federal tax law.
Thank you. Secondly, is it not true that Georgia aggressively recruits foreign students to attend its colleges and universities? Not putting aside undocumented students who are within the state of Georgia, does the University System of Georgia aggressively recruit foreign students to attend the colleges?
Our research universities do in particular, but we have international students in all of our campuses. To my best of my knowledge, they do recruit and admit.
And has there been any conversation, or both anecdotal or internal, that addresses the chilling atmosphere that the imposition of this type of law could have on those students who find the state of Georgia to be inhospitable to foreign students?
No, we really haven't discussed that, and anything I might say in that regard would be, just hypothetical. But my sense is that in terms of international students continue to be interested in our system, particularly our research universities, I have not detected any chilling effect by this law.
Thank you.
We did lose a football player to University of Georgia. But
thank you. Was there a follow-up?
Yeah, I want to correct to Chairman Ramsey. I'm told that 350 is the exact enroll number of all students. It's not just last fall. I'm sorry.
Oh, it's okay. And this actually leads to my next question. So in order to determine that number, if this bill were to be passed and this became legislation, would it not be correct that now all of the universities, all the schools in the university system would have to put in place a bureaucratic process in order to evaluate and determine the legal status of all students, as opposed to simply the 5 flagship universities that you've identified?
All of our schools now go through a process to determine whether they're undocumented or not.
Okay.
We do that already.
And do you believe that there's a fiscal impact to making this decision?
There will be some loss of revenue, but I want to stress, though, that is no reason. That is absolutely no reason why we have the policy we do. Mm-hmm. The out-of-state students do pay about 3 times what the in-state fee is, and with 350 students, there would probably be an impact between $3 and $4 million.
Okay.
But that is not why we do that. We don't see this as a revenue generator.
Yes, sir. And my last question is it not true, or is it true, that undocumented students tend to pursue documentation while in college, and that it's often the case, and again, as you know, I enjoy hypotheticals, that it's possible that by being in these schools that they may improve their documentation, they may improve their ability to receive documentation and remain in the state as lawful citizens?
Well, I have no way of answering that. Absolutely. We think many of them do begin the process, and as my understanding, our schools do encourage them to begin that process. But I have no way of knowing how many that applies to.
Thank you, sir.
Ms. Neal.
To the Chancellor, it's just a simple question as far as you say yes or no, or just tell if you're familiar with explaining how healthcare costs directly correlate with the collegiate admission process or tuition rates.
I have no basis. I understand what the Representative Hatfield was talking about, but I have no way of in any way documenting or calculating what that impact would be.
Okay, thank you.
Mr. Pack.
Thank you, Mr. Chairman. Mr. Chancellor, I'm trying to get an understanding of the cost benefit, because I think that, and correct me if I'm wrong, the primary goal of the university system is to educate. It's not necessarily to set public policy or look after the public money, and that's generally the role of the legislature, right?
Yes, but we also take very seriously our responsibility to be sure the
Understood.
public funds given to us appropriately, that we're good stewards of that.
Mm-hmm. Understood. And I think it's very important, and I think also Mr. King brings up a good point about some of the costs, and I'm trying to understand the cost benefit of changing the policy, or I guess trumping the policy set by the regions. Senator Loudermilk said that since these individuals, since they're out of status, they can't work. What is there any studies done of graduating people who are illegal, out of status, or whatever they call it? What do they do for a living once they leave the university?
I have no information on that. I don't know. I'm be surprised if there's not some research being done, but that would be an issue not only in this state but about the other 45 that has a very similar policy as we do.
Okay. And the flip side, and I see, and maybe you have some data on this too, since we're forced as a state to educate, regardless of status, from K through 12, how much money are we using as public taxpayer money to educate them, and determining whether or not to allow them to enter public colleges and then qualify and pay their way? What is the kind of I guess the cost benefit analysis of, is there a possibility for us to get that money back, versus is it just something that we just have to kind of cut our losses? Does that question make any sense? Because what I'm lacking now is I don't have enough data to understand if this is a good policy for the state or not.
Well, I think ultimately the real policy question here is, money aside, is whether you want these students who are in this country through no fault of their own, have finished our high schools, and are now ready to and willing and meet the requirements to secure a post-secondary education degree, if we want to give them that opportunity or not. And this legislation says no. And that is a policy issue that rests in the body of the legislature. We disagree with the proposal, but I assure you, if it is passed, we will enforce it.
Maybe, I don't know, maybe Mr. King has answered that. I just don't know what happens to them if we were to educate them by going to the public institution. Do they become a further burden on public, versus do they become contributing members to pay back some of the money we invested in? That's kind of cool. Any help you could get or your staff could get would be great.
We'll look into that. I'll be surprised if there's any data that, again, the comment has been made, well, if they can't get in Georgia's public institutions, they can always go to a private school. But I would say there are many instances in which the kinds of programs, the subjects, the disciplines that are offered in public higher education institutions may or may not be available in the private schools, and certainly in all locations around the state.
Chancellor, I see no further questions. Do you want to make any closing comments?
No, I just thank you for your attention, and if you think of other issues or questions, we'd be happy to try to respond in any way we can.
Thank you very much.
We're still keeping your seat warm,
You may need to.
I'll call on, and if I'm mispronouncing, I apologize in advance, Azadeh Shashahani. Is that correct?
Yes.
How about that?
Thank you very much, Mr. Chairman, and thank you, members of the committee, for allowing me to testify. My name is Azadeh Shashahani, and I'm an attorney with the American Civil Liberties Union of Georgia. And we would like to urge committee members to vote against SB 458, particularly because of two provisions of the bill that we find objectionable for a variety of reasons. One of them is the proposed ban on public higher education, which we oppose for various reasons, because we believe that it's fundamentally unjust and economically short-sighted. And also the current policy of the Board of Regents, we would like to note, is in complete compliance with federal law. The Department of Homeland Security has stated in unambiguous terms that federal law does not require that the state colleges ban or limit enrollment to undocumented students in post-secondary educational institutions. As Department of Homeland Security has itself informed the state educational institutions, such as in North Carolina, admission to public post-secondary educational institutions is not one of the benefits regulated by the laws that passed in 1996. To meet the statutory definition, quote, a state or local benefit, a program, including a post-secondary educational program under federal law, must provide payments or assistance to an individual by an agency of a state or local government or by appropriated funds of a state or local government. Again, this language does not cover mere enrollment in an institution of higher education. And we also oppose another provision of the bill which amends the language of House Bill 87 by excluding from secure and verifiable documents any foreign passport unless the passport is submitted with, quote, a valid U.S. Homeland Security Form I-94 or I-94A or other federal government federal document specifying an alien's lawful immigration status. We believe that this provision effectively imports one of the most controversial and most burdensome aspects of Alabama's law. It will essentially prevent immigrants from engaging in a broad range of interactions with local governments and the state government on the basis of their failure to present ID, even though they have a passport, the most secure form of ID issued by their country of citizenship, and a form of ID accepted by the Federal Transportation Security Administration for airplane travel, where security is tantamount. While the bill purports to aim to simplify administration of HB 87 and relieve unnecessary burdens imposed on people and state and local governments, this provision threatens to overshadow the other reforms and push Georgia in the complete opposite direction, injecting new controversy, potential litigation, and reputational harm. Though the provision seems innocuous, it would have a similar effect as provisions enjoined in Alabama. It would deny many immigrants water and sewage service as provided by local governments, by city and county governments, access to municipal buildings requiring ID, and the ability to enroll in elementary schools requiring proof of ID. Also, the ability to marry. We know that in many counties, including Fulton, a foreign passport is an acceptable form of ID in obtaining a marriage certificate. If this bill were to pass with this provision included, undocumented immigrants will be denied the right to marry, which is a fundamental right under the U.S. Constitution. And lastly, this is not going to only affect undocumented immigrants. Foreign visitors from mainly European countries, including England, Sweden, and 34 other countries participating in the visa waiver program do not have the forms required by the bill, because the visa waiver entrants traveling by air and sea are no longer required to use an I-94 at all. So what message is this provision sending to citizens of the countries that they have close relationships with, that their passports are not trusted under Georgia law? And it creates another unfair burden on local governments, preventing them under threat of criminal prosecution from accepting ID that is secure as recognized by the Attorney General. In short, for the reasons that I just spoke about, I would like to urge you to vote against SB 458.
I see no questions. Thank you very much. A call on Maria Duarte with Galeo.
Thank you, Mr. Chairman. Good afternoon. I am Maria Duarte. I'm Program Coordinator with the Georgia Association of Latino Elected Officials, or GALEO. GALEO is a nonpartisan nonprofit who focuses on increasing civic engagement and leadership of the Latino community in Georgia. I thank you for this opportunity to bring you our concerns about SB 458 and the provision in the bill banning undocumented students from attending Georgia's public colleges and universities. I come before you to make you aware of how Georgia students of all ethnic backgrounds, citizen and immigration statuses have come together in solidarity to protect all students' access to education and ensure the well-being of their peers. In particular, one youth group called HEROES is a group of students who participate in SEPA, a behavioral and mental health services clinic in Norcross, Georgia. HEROES was created for students by students to help prevent suicide among teens. Last year, after the suicide of an undocumented student from Texas, Joaquin Luna, a bright student who excelled in school and was brought to the U.S. as a small child, because of his desperation, of having limited options to attend college and lost hope in the passage of the DREAM Act. Heroes thought it was critical to raise awareness of the suicide risk and mental health issues that could rise if undocumented students lose hope in the passage of the DREAM Act. So they produced a video inviting students to keep their dream alive. I have a letter to each of you from Dr. Pierluigi Mancini, he's the CEO of SEPTA, on Heroes, their video, and the Heroes' commitment to prevent undocumented students, our children, from taking their lives because of short-sighted laws and hostile political rhetoric. Moreover, this weekend, at a student-led leadership conference, we got over 100 letters from students, Latino, Asian, African American, white, citizen, and non-citizen, asking you to vote no on SB 458. Most of the students there were citizens, future voters who stand in solidarity with their immigrant peers. We urge you to vote no on SB 458 with our students and children in mind, children who are justly seeking nothing more than a chance to obtain higher education. When the DREAM Act passes, Georgia will fall behind economically and in educational attainment. And with the passage of SB 458, Georgia runs the risk to lose the lives of innocent, bright children. I close by quoting Heroes in the video. They say, "How many dreams must be extinguished before our dreams come true? House Committee members, do not extinguish dreams. Vote no on SB 458. Stop erecting barriers to higher education." Thank you so much.
Ms. Abrams, did you have a...
Ms. Duarte, earlier I asked a question of the author. Are you aware of any situations where a student might be undocumented, maybe undocumented, but may receive documentation during the course of their matriculation, typically because of some bureaucratic delay in providing the documents they need to enroll?
Are we aware of those situations?
Mm-hmm.
Yes.
Can you give an example?
I don't feel comfortable giving an example. I would invite Gallo Executive Director to take that question, if that's all right.
If the chairman would allow.
Mr. Chairman?
If he's saying the same thing you would say, what was... So you are aware or you're not aware?
I am aware, but she's looking for a specific example.
Oh, you're aware in general, but not specifically?
Yes.
I'm sorry.
Yes, sir.
Okay, sure, that's fine.
Okay, thank you.
And it comes with sound effects.
Apologize for that, Chairman.
That's all right.
Thank you for the opportunity, Leader Abrams. Yes, there are situations in which a legal immigrant student may be out of process with their paperwork, and it's a bureaucratic process, and that's why there are immigration attorneys that help these legal immigrant students, foreign students that the university system has and encourages and recruits for them to come here that would at some point in time be out of status, that wouldn't be able to prove their status simply because of a bureaucratic delay. That's why immigration attorneys are so important in that process as well.
So under the terms of this legislation, because I think the question would be if at some point they were if they ever had proper legal status and they became undocumented, would this bill impact their ability to attend? So is there a situation where a student is a high school student applying to college and would not be able to meet the 9-month timeline for providing the documentation necessary, even though they have followed all of the processes necessary in order to become documented students?
That could be the case of a legal student in high school that for some reason, because of age changing visa status, potentially could be out of status for a period before they would become back into legal status. Again, I speak from general working knowledge of immigration law. I'm not an immigration attorney, but that's why immigration attorneys are so vital to this, and it would be a good thing for the committee to consider consulting with immigration attorneys before moving such a broad, sweeping legislation like this.
Thank you, sir. Yes. Thank you, Mr. Chairman.
Mr. Gonzalez, I'll ask you the same thing. What's very important, I guess compelling to me, is that Senator Loudermilk said, and this is true, that once you graduate, if you're out of status or illegal, you can't work. Am I right about that?
Legally, you're not able to work. Yes, that's correct.
What do we educate these people who are out of status who can't work by providing them we tax subsidize public universities? How do they become self-sufficient and not be a burden on the public fisc?
Let me remind the committee members that even during the Republican presidential debates, many of the leading presidential candidates supported a version of the DREAM Act. The DREAM Act is going to pass at some point in time in the near future. I think it would benefit us as a state in the long term to ensure that these students do have an education that will be able to contribute, become much more better contributing members of society once they do become citizens, because it's not a matter of if the DREAM Act will pass, it's a matter of when. So Rick Perry went even further in Texas, where the governor has and helped usher in-state tuition for undocumented students in Texas universities to ensure that Texas remains a viable state to be able to compete in the global marketplace. So Governor Rick Perry of Texas, a very conservative governor, moved for in-state tuition. What we're talking about here is denying access to higher education, and that's even some of the leading Republican presidential candidates supported a version of the DREAM Act. Okay. So I think that we're moving in the direction of this eventually happening. I think we can benefit as a state to ensure that all of these students are educated rather than not educated, and we can allow the university system to really uphold its mission of making sure that they focus on education rather than being immigration cops.
Well, I appreciate that, but you didn't answer the question. The question is, until that happens, how do they support themselves other than becoming a burden on the public?
I can't speculate in those specific situations because technically they can't get jobs, but that doesn't mean that they don't. We have 50 to 70% of Georgia's agricultural industry relies heavily upon undocumented labor. Senator Saxby-Chambliss has said so time and time again, but they're still here working, supporting our $68 billion industry. So people do get jobs without documentation in our state, even after HB 87 had passed. That's still the case. That's still a fact. So that's not what should be happening.
I understand.
We need to reform our immigration policy.
I understand that, but okay. I think people who work in the agriculture business probably don't go to college to do that. Am I right about that?
Actually, sir, that's not accurate. There's many students that grew up in agricultural communities that have gone on to college and have benefited from having access to higher education, and they are supporting and helping their families right now in Georgia.
But they would be working against, I guess, outside the law. Am I right about that?
As are 60 to 70% of Georgia's agricultural workforce as well.
Mr. Setzler.
Mr. Chairman, appreciate you being here today. This is an important conversation. Leader Abrams referred to hypotheticals, and I don't want to spend too much time on hypotheticals, but I do want to ask you a question that I think gets to the first principle issue. If I were, if I went home and left the Capitol and showed up at home and pulled into my driveway, walked into my house and discovered that, wait a minute, it sounds like there's somebody downstairs in the basement. And I walk downstairs in the basement, I see that an entire family's moved in. You've got mom and dad and kids, and they've unpacked their luggage, and they've brought in furniture, and they've moved into my basement. Am I in a position to say, wait a minute, what are you doing in my house? If they came into my house uninvited, moved into my basement, and took over.
I think we need to look back at Georgia's actions during. I'm speaking specifically into this situation that you're referring to. During the 1996 Olympics, we invited immigrants to come here from all walks of life, including undocumented immigrants. Our agricultural industry is heavily reliant upon undocumented labor. We've invited undocumented immigrants to come support our thriving economy in the agricultural industry. So your analogy is false because of the fact that I think because our immigration laws have been broken, we've invited people to circumvent those immigration laws because we need them in order for our economies to prosper and thrive. So your analogy really doesn't make any sense, because in that situation, to make it more accurate, you invited these people and then you're expressing surprise that they're there.
So the question really focused on the first principle issue. In fact, I got this analogy from a gentleman I know who works in a community where probably 50% of the people he goes to church with are illegally in the country. And he has a lot of folks come to him. They say, well, why do people have problems with illegals having free public access to these public benefits and those public benefits? He said, listen. He said, it's as if if I came home and I walked in and I found that you had moved into my basement, and I said, what are you doing in my house? And they said, hey, well, we didn't have a place to stay, and you've got a really nice basement. And there wasn't a family living there. So we came in and we put some groceries in the refrigerator, and it's a great place to live, and we're not going to let you make us leave. You have no right, sir, to kick us out of your basement, even though it's your property, even though it's your house.
The analogy is based on a false assumption that undocumented immigrants have access to all these public benefits, which they do not. Under federal law, that's not the case. They don't have access to any public benefits, excluding K through 12 education and higher ed education. So it's based on a false assumption.
Sir, I'm afraid you're talking on both sides of your mouth, sir, with all due
No, I'm not.
respect. You affirm access for illegals to have access to public education K through 12.
Yes.
You affirm
it's federal. It's a U.S. Supreme Court ruling,
and
1982, Plyler versus Doe.
Indeed, you do, and you affirm that.
Yes.
And you're further suggesting that someone ought to.
I didn't affirm that. The U.S. Supreme Court affirmed it.
Right, and you believe that's.
Let's suspend for just a minute. I need you to take the level down one peg. We're not going anywhere.
Likewise.
We're Mr. Gonzalez, we're talking to each other, not at each other.
Okay.
Okay. Thank you.
I'd expect the same courtesy, sir.
And you're getting it as far as I'm concerned.
Okay.
And as we walk through this, it's your contention that ought to be the law, that not just the Supreme Court's case law. You believe that ought to be the law of the state. You believe it ought to be the law of the state that people who are here in this country illegally ought to have unfettered access to higher education. You lifted up Texas as a model that they receive in-state tuition. And I would simply say to you from a first principles perspective, every person in this room, every person, whether they would admit it on camera or not, recognize that if they came home and someone had moved into their basement and had taken over and said, hey, you're not using your basement, we want to live here. Everyone in this room, if they were intellectually honest, would recognize that's an absolute outrage. It's an outrage. Not only is it an outrage, it's a crime that you believe and people in this room believe ought to be prosecutable if the person refused to leave. The question writ large is we have people in the state who are here illegally. They've broken our laws. And I don't think anyone in this panel is suggesting they be treated brutally. I certainly don't support that. But to suggest that people ought to have unfettered access to institutions of higher education it's just not rational. It's no more rational than if I were to get on a plane and go to Sweden and go and register for their public health system and expect to get free benefits, expect to put my kids in their university system. They have a much broader, much more expansive, much more lavish public welfare system than we do in this state. And to suggest, sir, that I'd have access to that would be I'd be laughed out of Europe if I made that supposition. But for some reason, I'm hearing, with all due respect from you and others, that people who are here for whatever reason, whether they're invited or whether they broke the law to be here or they overstayed their visas, ought to have unfettered access to benefits that people who are here legally from other countries have access to. But those who chose to break our laws, you're suggesting should have access to. I can't follow from the first principles perspective how we can get there as a state.
Kate, a couple of things, Representative. I think that this unfettered access comment is not accurate. Again, it's not my belief whether children should have access to K through 12 education. It is the law of this land that you've sworn to uphold. It's not a matter of opinion whether I believe that or not. It is the law of the land that you've been sworn to uphold. Furthermore, as the Chancellor has suggested earlier, having access to higher education is not against federal law. And that's, again, part of the law that you've sworn to uphold. It's not speculation. It's not my belief. It what currently is in place. What I am urging for is a moderate approach on this issue. We're talking about the lives of young, innocent children all across this state of Georgia that are looking at this bill as a really dashing of their dreams and their hopes, and some are contemplating suicide. That's real life. It's not speculation. It's not my belief. I've talked to some of these kids. So when you're talking about unfettered access, I think you're misinformed on what the law currently is and what you wish it to believe it to be.
If I went to Sweden and took my kids there, and they were seeking access to the public welfare system, they were seeking access to institutions of higher education, and they said, "By George, I was brought here by my dad. You've got to give me access to it, or I'll threaten to commit suicide." Would you submit the nation of Sweden ought to give my kids a free public education because they threatened to commit suicide, or because their dad drugged them over there? Or do you think that I and my wife ought to be able to get access?
We should bring in the Swedish consul and answer that question. I'm not equipped to answer that question. I'm sorry.
I would note that I don't think Mr. Setzler was debating K through 12. I think that's well established, and I don't think anyone's debating that.
No, his reference was to that I believe that was the case and that they should have access. The fact of the matter is, it's not my belief. It is U.S. law. It's upheld by the U.S. Supreme Court.
And
so
no one is debating, no one is questioning that or arguing back on that with regard to K through 12. That's the current state of the law. But
my interpretation of what he was saying was he was suggesting that it was my belief.
I mean, we're hair splitting and wordsmithing. If no one is debating the K through 12, we're here talking about beyond that. I think we're all. I thought we were all clear on that. Ms. Bird. No, Ms. Benfield.
Thank you. Thank you, Mr. Gonzalez. I just have one question with regard to the issue raised by Representative Pack about the types of jobs undocumented immigrants can get upon graduation. Is it true that undocumented immigrants can open their own business?
I know that many have, yes.
Thank you.
Ms. Abrams.
Thank you. To follow up on Representative Benfield and Representative Pack, is it not also true that often undocumented students who matriculate through university use that opportunity to apply for legal status and use their proof of being fit to receive documented status? They use the fact that they are indeed students in college and that they've maintained good GPAs, and they actually use that in order to secure legal status and then use that in order to go into the workforce.
I do understand that there's been several cases like that that I am closely familiar with, that students were able to adjust their status after that process, yes.
Thank you.
Ms. Abdul Salam.
Thank you, Mr. Chairman. Just want to go back for a little bit of discussion a while back. Was on the issue of actually having real life instances of someone being, I guess, held up in the bureaucratic process of becoming legal. One of my constituents, her name is Patricia, about 2 weeks ago came to me for help because her daughter is currently in a Georgia university, and she's been going through the process of becoming legalized. She has made application. They've actually been so far as going to the interview. I was born here, so I don't have the luxury of actually knowing exactly what it is that they have to go through. But she's gotten to the point of actually going through the interview. And right now she's fearful and in jeopardy with her college education because the time is running. Through no fault of her own, her daughter may not be able to complete her college education here in Georgia. She came here at the age of 6. She attended public schools here. She excelled as a student, and she's in college. But what they're having problems with now is that the documentation process is taking so very long that they are in jeopardy. And I was glad to hear you mention immigration attorneys, but in some communities we don't have them. And so what I've been literally trying to do, and it is a real right now case, is trying to find somebody that has some expertise and information with regards to immigration. But this is a real a situation. This young lady happens to be from Gambia. And so she thought that once she got to the interview process, then everything else would just be kind of automatic and happen very quickly. It's been a year and a half. So I wanted to kind of just share that for those that were saying, you know, are there real life examples? Yes, we're dealing with those all the time.
They're very real life examples that have very negative impacts. In fact, the Chancellor made a reference to it a little earlier about a University of Georgia football recruit that somehow did not have the appropriate documentation to be able to be enrolled in the University of Georgia. And the University of Georgia lost a significant football recruit because of that lack of process. So the current policy in place is restrictive for Georgia. It does shine a negative, repressive light against Georgia, and many foreigners and international students that are looking at Georgia would rather not look at having to deal with the bureaucratic mess that they would have to deal with regards to this, and may choose other institutions outside of the state rather than come to a state that's hostile towards immigrants. That's what Georgia's reputation is, and that's why Georgia lost a convention of the American Education Research Committee that potentially cost the city of Atlanta $25 million because of its current hostility towards immigrants that Georgia is perceived to have.
Again, my main concern is that the students have no fault in this, but the consequences have everything to do with their lives. And it is, I agree with Representative Pack. I could feel his sense of, I guess, confusion in. So we're educating them K through 12. By law, we have to, and I think that that's the right thing. But after that point, we cut you off, and you're just out there on your own. And he asked at one point, his question was, can we get our money back? And again, you know, out of frustration. But my thing was, why would we invest K through 12? I understand the law, and they can't drop out until they get 16 because of Georgia law. But the state tax dollars as well as the federal education dollars are provided. And, you know, the school systems in the state of Georgia has not opted out of taking those monies. So it really does create an interesting dichotomy.
It does, but I would also remind committee members that 45 other states have chosen to provide access. There's only 2 states that deny access. If this bill moves forward, Georgia would be in the extreme rather than in the mainstream, as Chancellor Huckabee said. So states are erring on promoting access to education rather than denying access to education. I think that's a smart, moderate view that the state of Georgia should uphold, and I would hope that the committee would support the Board of Regents' position of not moving this forward.
And one last point, Mr. Chairman, if I may, in dealing with the current request for assistance for one of our college students, one of the things that I've heard repeatedly is that we follow steps A through Z, and then the process changes. And depending on who you're talking to on Monday, it's one thing. You go back the following Wednesday, and it's something else. Do you all have a sense that there's a lot of confusion, and maybe sometimes people get lost in trying to get the documentation because the rules keep changing?
Immigration policy is more complicated than our IRS tax code. So it is a complicated process. It is something that people benefit by the use of immigration attorneys. There are very few immigration attorneys that do pro bono work, but we can certainly, if you can provide me with the information, we can maybe connect the young lady or young person with someone that could possibly help.
Thank you so much.
I see no further questions. Thank you, Mr. Gonzalez.
Thank you, Chairman. Appreciate it.
Yes, sir. I'll call on Susan Stanton with the Madison Forum.
Mr. Chairman, committee members, I'm Susan Stanton from the Madison Forum, and I just want to let you know that I do support this bill. Thank you very much.
Thank you very much for coming down here today. I'll call on Mr. Wendell Phillips with the Presbytery of Atlanta. Oh, he was leaving. Okay. Mr. McKenzie.
Thank you, sir. All right.
If we could limit our comments to just a few minutes,
Yeah,
and then in case there are any questions.
my clock here.
That's
so,
all right. We're not going to cut you
long.
off, but if we could.
Right.
Thank you.
Okay. I'm a public school teacher. I'd like to real briefly tell you about two kids. One young lady, I'm going to call Maria, who 1 year she was legal, 1 year she was odd. She was, she got lost in the system. She came and sang at my church. She sang, "In God's love, there's no stranger. In God's love, there is no orphan." She was a straight A student. I'll be proud to have her for my daughter. I'm very proud to have taught her. I would also like to tell you about another young lady that I taught. I'm going to call her Julia. She graduated from the high school I was teaching with a 4.0 average. She led our school in the Pledge of Allegiance every morning with liberty and justice for all. She is now a 4.0 student at Dalton State College. Thomas Jefferson talked about some things being self-evident. We've mentioned first principles. It seems to me that it's self-evident that these are good kids you don't want to hurt. I got into teaching because I want to help kids, and I think that y'all, especially the swing votes here, I don't know who you are, but the swing votes here, I think you got into politics because you want to help people, not hurt them. I think that your parents are proud of you when you went to school, like these two young ladies, and that the reason they're proud of you is because you made good grades and you were going to help somebody someday. And I've got to go home to my kids, and I got to look them in the eye, and I got to say, son, I stood up for kids today. I stood up for the people I'm trying to help. You got to look your kids in the eye, too. And I wish you could look these two young ladies in the eye on a regular basis and then get so fired up about our analogies that we make. Let me tell you something. These two young ladies never asked to stay at my house. America's a big country. There's plenty of room for a lot of people here. And these two young ladies just want a chance. The General Assembly has no business passing the college section of this bill. The General Assembly already acted last year. Why beat a dead horse? This time, let's follow the example of Arizona and move on. Turn the page. A lady I talked with last year, this time from the Tea Party, I was talking about the kids I was concerned about. She said, I believe in HB 87, we've got safeguards to protect the innocent. Well, maybe we did, but now we're trying to get rid of them. Let's protect the innocent. These kids were brought here through no fault of their own. They have done everything. It is following the parable of the unmerciful servant, because we have all done worse things than a 4-year-old does when they obey their parents. We've all done worse things for that, and then we're going to turn around and ruin somebody's life. And I'm not sure quite why, because of analogies that we make. Why would we do something like that? 48 states don't do it. Why do we, if our lawyers are telling us that we have to do that, we need to get some different lawyers. 96% of the folks across this country don't do that. It cost Alabama, their immigration law last year cost Alabama billions of dollars. On the money issue, this is about right and wrong, by the way, I believe, but on the money issue, it costs us money. It doesn't make us money. In the analogy that we heard, you've got student A, student B, $15,000, $5,000. They're not competing for seats, so you keep the $5,000, but you get rid of the $15,000. All right, so it's not going to make us money. The bill sponsor, Senator Loudermilk, in other situations talks about the need to accommodate church and state, to bring back a sense of the sacred in our politics, that we have too much of a wall of separation between church and state. Well, I'm going to agree with him. I'd like to quote a little bit of a scripture. In Leviticus, it says, love the alien living amongst you as yourself. Treat him as one of your own. In Matthew, it says, blessed are the merciful, for they will be shown mercy. Forgive us our trespasses, as we forgive those who trespass against us. We've talked about the parable of the unmerciful servant. Christ says that we will be judged ultimately, not by the voters, not by the constituents, not by our buddies in whatever political party we are, but ultimately by how we treat the least of our brothers. We have turned undocumented immigrants into the lepers of our society, and I believe we will be judged by the way we treat them. Paul, the Apostle Paul, says that the fruits of a Christian spirit are love, gentleness, and kindness. The section of this bill that would ruin Maria's life, Julia's life, is neither kind, nor loving, nor gentle. We shouldn't do it. We are Americans. There's a flag outside the courthouse. That means certain things are set in stone. Who we are, what we'll do, what we won't. We should not hurt little innocent kids. It's self-evident that we don't do something like that. Mr. Gonzalez, in a previous talk that he said, liken this to bullying. And once again, I'm talking to the swing voters. It's good politics to pick on the weak. It's good politics. This is an old story. Now it's our turn, and it's always been good politics to pick on the weak. Governor Faubus in Arkansas, who tried to keep out the Little Rock Nine, do you know that he was the most popular man in America in 1958? It was good politics to stand up in front of those kids. It's good politics. But those of us who are not benefiting politically, who are torn, well, I don't know, it doesn't seem like the right thing to do. It's self-evident that's the wrong thing to do. We've got to find the courage to stand up. Peter in the Bible said, Jesus, I got your back, man. I will be there for you. When push came to shove, he didn't have the guts. And Pontius Pilate said, hey, I would like to help you out, but it's my job to hurt you. I wash my hands of this. You got to look your kids in the eye.
I need you to lower your voice.
Yes,
please.
Sir.
It's just a little too loud.
Okay.
I realize you have a certain passion about this.
Absolutely. I do have a certain passion about this.
That's clear.
I've got to look these kids in the eye when I go back. So I will, in a low voice, conclude.
Okay.
I would like to ask you folks who are in the middle, not the folks who are benefiting from this, but you folks who are in the middle, find the courage to be the man and the woman that your parents raised, and the mother and the father that your kids are going to look up to. This is about first principles, ultimate principles, not petty politics. Thank you very much.
Thank you, Mr. McKenzie. Let me call on Mary Graybar, if I'm saying that correctly. I hope I am. Ms. Graybar, if you could, the same admonition to you, if you could keep your comments limited to allow time for questions.
Thank you. Thank you for the opportunity to testify on behalf of Senate Bill 458. My name is Mary Graybar, and I live in Stone Mountain. I hold a PhD in English from the University of Georgia. I have taught there and in several other colleges and universities of the University System of Georgia. I now teach part-time at a private university in Atlanta and work as a writer focusing on education issues.
What university do you teach at? Just out of curiosity.
I am not a regular employee, but I do teach at Emory.
At Emory,
but,
okay.
But I do not say that because my job is in jeopardy for the political positions I take. And it's not a political position, actually. So what I want to say here is that my views are my own as I speak today. They do not represent the views of my employer. And I also want to add that I have been teaching college for almost 20 years now. On February 4th, I attended the Teach-In on Tucson at the Georgia State University College of Education. Although the purpose was described on the website as facilitating discussion of curriculum and censorship, what I found was a rally for activists opposed to Georgia's efforts to restrict benefits to illegal aliens. The provisions of the Arizona law were not even discussed. Instead, workshops focused on how to use banned materials in the classroom and how to lobby against immigration bills. One of the 3 workshops was titled, quote, "Here Are Voices, Letter Writing Sessions." I was shocked to hear one education professor, and I've named her name in an article I've written, at Georgia State University openly pledged to bribe students with, quote, extra points or extra credit for writing letters opposed to bills restricting benefits to illegal aliens. This is a serious violation of all ethical standards for teaching. I would never dream of doing anything like that. It also throws into question the source of letters opposed to SB 458. How many of them were written in order to gain better grades? At the workshop on using one of the banned books, Rethinking Columbus, were 3 education majors in music, physical education, and history. They were from Clayton State University and Georgia State University. This was in one workshop I attended. I wonder, did they attend in order to fulfill an assignment? This teach-in had no educational purpose in my view, yet it was co-sponsored by 2 deans and several professors from Georgia public universities, along with activist groups. Listed as, quote, supporters were 24 individuals from Georgia State and 1 from Kennesaw State, among others from the media, activist groups, and the curriculum company called Rethinking Schools. I have written an article about this. It's on my website, and it has more details on it, and I thank you for the opportunity to speak about this issue.
So, is it Gray Bar? Is that right?
Yes.
So, just to make sure I understand, at Georgia State University, there was a seminar or some sort of program given where employees of the university system use that. Is it your contention that they use that as a platform for a lobbying effort against certain legislation? It wouldn't matter what it is, frankly. I mean, whether it be this issue or something completely unrelated, but use that as a forum to increase lobbying effort against a particular issue, and one or more that was sponsored by one or more administrators of that university and one or more instructors within that forum, employees of the university, use that effort as a, or I guess offer extra credit for students to take a particular political position and to communicate that position to members here.
That is correct.
I know, that's what we're doing. I mean,
that is what I heard there, yes.
Okay. I mean, is there anyone that I mean, if we ask the individuals involved, are they going to deny that, or are they going to, or I guess we'll just ask them, won't we?
I know what I heard, and I.
Well, I'm sorry. Were you there?
I was there.
Oh, okay.
Yes, yes, I was there for the whole thing. I heard it all.
Okay.
Yes.
Was this a program that was publicized and?
It was publicized.
Like other programs
yes.
are, come join us, etc.
Yes, the public was invited.
Okay.
There was no cost for it.
Okay. Ms. Bird.
Thank you, Mr. Chairman. I would assume it's no different than a letter I received from a constituent that goes to a university and the adjunct professor said, "You are in my class and I am a Marxist and I am going to change your mind." Any different?
I think it goes a step further because I see it as bribery for grades. You are asking someone to lobby for particular legislation for a grade. The function of a professor is not to promote an ideological or political position. It is to educate. So I see it as being sort of in line with that, but this goes a step beyond, and I have quite frankly never really witnessed that in 20 years in education.
Well, it goes both sides, so thank you.
If that's true, and you know, look, this is secondhand information for people at this side of the table, but if that's true, that's an extremely disturbing reality just from a pure academic ethics standpoint. But there are 2 sides to every story, and sometimes there are even more than 2. And so we're going to explore that a little further on a separate track down the line. I'm not going to put any particular official on the spot on that, but that's not something that it just goes away. Because if it doesn't get explored, then it just gets exploited in the future. That's a fact. We appreciate your testimony. Thank you.
Thank you.
We're just going to go ahead and go down the line here. If there are people who are, we're not engaging in a dialogue here. This isn't, this is if you come and testify, that's great. We're not shouting out and, doing that. That's not the way the system works here. I'm sorry, Satuan Cox. I'm sorry, thank you. With DeKalb Path Academy.
Satuan mean animals.
I'm sorry?
My name is Satuan, and Satuan mean 100% gold. But when you call me Satuan, it mean they animals.
I apologize.
so
I can't think of anything else to say but that right now.
So most people would opt for Miss Cox. They would say Miss Cox.
Well, that's the safe route to say Ms. Cox, but I didn't want to take the safe route. But thank you for being here.
Thank you so much for having me here, and I speak as an immigrant, a documented immigrant with document. And 34 years, 3 months, and 4 days ago, I followed my heart. I married a Peace Corps, and I migrated to this country. And my mother always said that most stupid thing I ever did is follow this poor man back to the U.S. In the past 34 years, I've been working as educator, and I do whatever it takes. And 34 years here as an immigrant, an Asian woman with an accent, with a master's degree in English Lit, it doesn't work. They all expect me to have an accounting degree. But then I end up being a teacher, and I was one of the best teachers in the state. In fact, 12 years ago in this assembly, you have a resolution to declare that I was one of the best in the state. I was the Milken educator with other three. I still have that big piece of paper, and I frame it, and I have all this. I was Gwinnett County Teacher of the Year and so forth. And in the past 34 years, I tirelessly work for all these children of mine who are immigrants. I work in the refugee camps, and I follow them back. And I tirelessly work to create a heaven, a little heaven in my school. Right now I run a charter school for 350 kids. And today I speak as an immigrant, not as a principal. My students, 70% of them are immigrants. And the other day I felt like I'm a priest who lost faith in my God. A Catholic priest that look up and talk to God and say, God, have you heard me? When my kid asked me, Miss Cox, will they come take me away because I have no paper? And this is 10 years old, and I said, no, they take me first. And I will never let that happen. And when someone talk and the analogy of, your basement, someone move in and so forth, I was sitting here thinking that what the native Indian probably think the same thing. Maybe their immigration law is not strong enough. If their immigration law is strong enough, we probably won't be sitting here. I'm here today just to ask you, if I tell you that, please, just like all the other that keep telling you, this is morally wrong, you say, Sutuan, don't you understand that they are not legal? But I'm going to tell you, like the others said, that it's financially stupid. Sorry for the strong word. You know what you need to do. You keep asking. You invest in these kids, K to 12. Each of them we invest at least the very least is 100,000 up to K to 12th grade, and then you won't let them lose. But you asking what going to happen, but I still thinking that it's better to have educated unemployed people than the non-educated unemployed people. But what you need to do is that, why don't you get them to work and ask them to pay back student loan, or you just give them job, they're dying to work. I cannot, like one of the teachers here, that go back to my student and keep telling them, by the way, my school is one of the best in the state of Georgia. We distinguished Title I school for the past 1,000 years. We have been 10 years, and we one of the best. We one of the second best in DeKalb County behind Magnet School. But the point here is that if you allow them to go to school, finish the school, you will have a group of people who are educated, and then you get them to work. You have, like, if they have this degree, they can work, and then they can pay back, and then they give you back your loan. You should be the people who started here. We need to change. These children is not Republican or Democrats or whatever. They are here to stay. What are you going to do with hundreds or thousands of kids who K-12 and then done cannot go to college and then walk the street? They end up robbing you. And what are you going to do? You're going to build more jails instead of building children. And this is my job as an educator, and I promise you I do my best. I go out and do my best every day, and I really pleaded with you. I urge you to think twice before you pass this law. And that's all I have to say, and thank you very much. And if you want to ask me anything, I will answer with my accent and all. And by the way, I'm a stand-up comic as well. I did my the punchline. You want to hear something, I have it as well. So, thank you so much.
I don't see any questions, and thank you so much, Ms. Cox, for being here. We have gone 20 minutes over the allotted time. I know that there are other committees that are commencing in 10 minutes, around 10 minutes or so. I'm just going to have to apologize to those people who were signed up and wanted to speak, but I'm not able to do that, not because we don't want to, but because we're on a schedule, and we do have to go ahead and keep that. There are other committees that are going to commence very soon, so we've had a good, exhaustive, thorough, honest dialogue, and with that, I'm going to ask right now, what's the will of the committee regarding Senate Bill 458? There's a move due pass by Mr. By the Vice Chair of SB 458. I'm looking at SB 4. I'm looking at CSFA. Let me make sure. I'm sorry. Yeah, I'm looking at the CSFA/1. Okay. There's a second by Mr. Ramsey. Are there any amendments, Mr. Coomer?
Yes, sir. AM 350286 is a two-page amendment that is on your desk.
Let's take a pause, make sure everybody's got the amendment. AM 350286. Does any member not have that? Okay, Mr. Coomer, if you could talk to the amendment.
Sure. The first page really, all of that language addresses removing the Immigration Enforcement Review Board from the definition of agency with regard to the Administrative Procedures Act. And you can see there lines, beginning line 16, going down through 20, a number of boards have already been exempted. And this is so that we can make the process less cumbersome than going to court for folks who have to go, folks who need to utilize that board. That really addresses the language all the way down to line 37 on the second page. And then line 38 through 42 strikes the language, the existing language that gives the Attorney General the authority to define public benefits, and instead is introductory language to a list of public benefits. And if you look at line 45, we're adding public post-secondary education to that list of benefits and renumbering appropriately.
Did you want to speak to that last beginning on line 54?
Yes, I think that's
on the notice piece.
In keeping with the change that we're looking at 41 through 42, we're simply
requiring the Attorney General to provide public notice listing the benefits that the legislature has determined to be public benefits in this list.
Okay. Ms. Neal, did you have a question on the amendment?
No, I had a minute.
Okay. Seeing no discussion on the amendment, all in favor of the gentleman's amendment, AM 350286, say aye. Aye. Opposed? No. The ayes have it, and the amendment is adopted. Are there any further amendments, Ms. Neal?
Yes, on page...
Could you pull the mic?
On page 4, page 6, pardon me, line 200, right after, well, back up, line 199, after shall, striking not, continue on, include any foreign passport, period, striking everything until 202 at the period, and then starting back up with only documents.
So you want to strike the insert language on line 1 that's begins with secure on line 199 and ends with the word status on 202. Is that correct?
Well, I don't want to strike the whole thing just in case it doesn't attempt to maintain what you're trying to do there. Secure and viable documents shall include any foreign passport, period.
Okay. So you're striking the not then?
Yes.
Okay, sorry. Ms. Neal's amendment on line 199, striking the word not. All in favor of the lady's amendment signify by saying aye. Aye. Opposed? No. The amendment is not adopted. Any further amendments? Ms. Benfield.
I had the same amendment as Ms. Neal.
Okay. Are there any further amendments? Seeing none, we have a do pass by substitute. I'm sorry, Mr. Ramsey. Or Mr. Setzler.
Were you to take any discussion from the committee before we vote, or?
I can.
Just I did want to make one quick remark because I didn't have a chance to ask a question to her.
Okay.
I was, Mr. Chairman, members of the committee, I was going to ask, would have loved to have asked a question of the Board of Regents. I regrettably had to leave for a period to go to another committee and vote on a bill in House Education. I'll simply say parenthetically, Mr. Chairman, it would have been my intention to ask a series of questions. I do know there's a process within the Board of Regents today. If there was a student who was, we talked about the difference between in-state tuition and out-of-state tuition. Out-of-state tuition, let's say it's $15,000 a year. Let's say in-state tuition is $5,000 a year. I know there's a process. If there was a student that was contending that they were an in-state student who didn't live in the state, they weren't a legal resident of Georgia, there's a major financial advantage, I think we all recognize, of being a resident of Georgia. There's a process today that if Joe Smith says, you know what, I'm a resident of Georgia, I want to get in-state tuition, I want to continue to do that, to demonstrate that, there's a process. And if there was an inquiry into that, the Board of Regents would have a series of tests to go through. Is Joe Smith a resident of the state of Georgia? No, the person doesn't. They didn't graduate high school here, or they don't currently live here. That's not their state of residence. There's a fairly rigorous process because this is a substantive issue that's before the Regents every day with thousands and thousands of kids. I would submit to you, and my goal would have been to ask some very leading questions. Would have had the Board of Regents kind of outline for us that process. But there's a very clearly defined process to do that. Just as the Board of Regents, I think, are charged and would embrace their responsibility to confirm whether a student is an in-state student and can receive in-state tuition, or if they're an out-of-state student and would have to pay out-of-state tuition. They take that very seriously. I know they do. And they do a very good job of that. There's a process of verification to confirm the student's in-state, be it through different identification, be it through residency records and so forth. I think this bill simply seeks to do the exact same thing. It seeks to ensure that if there's a student that's going to receive public benefits in the state, that they're in this country legally. And I think we as a state have the same obligation to ensure that folks are in this country legally as we do to ensure that they're an in-state student to get that in-state tuition benefit as an in-state student. And I think this whole conversation is just consistent with that process. The Board of Regents takes very seriously, and I think, frankly, the extension to include for legal residents is in keeping with that principle of good management that the Board of Regents does a great job of today, Mr. Chairman. We can commend this bill to the committee and just signify my urge for committee members to do pass.
Do we have any further amendments? Seeing none, we have a motion of due pass by substitute of SB 458/CSFA/1. All in favor of the gentleman's motion signify by saying aye. Excuse me, I'm sorry, but we have a motion. Thank you. Oh, that's all right. That's okay. We have a motion of due. Excuse me. We have a motion of due pass by substitute of SB 458/CSFA/1. All in favor of the gentleman's motion signify by saying aye. Opposed? No. The ayes have it, and the motion is adopted. We will have a meeting more than likely tomorrow or Thursday, depending on scheduling issues that I'm not quite aware of, but it'll either be Wednesday or Thursday. Now that I think about it, be more likely Thursday. But not tomorrow. But there'll be a notice that will be sent out in a timely manner on that for members, and we're adjourned.